Did you know that there is a way out of a default judgment if one's been filed against you? Stick around, because inside this video I'm going to tell you how you can vacate a default judgment. Hi, my name is Peter Lamont. I'm a business and personal law attorney, and I make videos like this to educate people and help them better understand the law, because I think it's a really powerful tool to understand your rights and obligations. So as promised, inside today's video we're going to talk about vacating a default judgment. So in a prior video we've explained what a default judgment is, and it's essentially when you fail to answer or otherwise move when you're served with a summons and complaint. And the plaintiff obtains a default judgment against you, meaning that whatever relief they've requested in their complaint is being granted simply because you didn't respond. So how do you vacate a default judgment? Well, good news. First of all, the courts favor litigating cases on the merits as opposed to giving someone a default, especially when money is involved. So here's how you do it. You have to file a motion to vacate the default judgment. And there are two things that must be in every motion. Now, it's going to vary from state to state, but in the majority of states you've got to be able to show two things. One, excusable neglect, a reason why you didn't answer the complaint. For example, you weren't served on time, you never received a copy of the summons and complaint. And then two, a meritorious defense, meaning you've got to be able to show the court that you do have a defense and that there's a reason for them to vacate the default, because you can defend the claim because of a meritorious defense. So it's just, a tangible, a real defense. Whether or not you can prove it's a separate thing, but as long as you can show the court that you've got some defense, then they're going to vacate the default judgment. Now, there are times that you should not attempt to do this on your own, and that's the majority of the time. Quite frankly, I'm not a big believer in saying that every legal matter that pops up you need an attorney for, because the truth is that a lot of things you can handle on your own. But once you've been served with a motion for default or a default judgment or any of those things, it's kind of gone beyond the stage that you should be handling it. In another video we talk about when you should handle something on your own and when you should not. But assuming that it is a relatively high judgment against you, and relatively high depends upon your level of comfort. For some people, $1,000 judgment may be really high. For others, it's a $10,000 judgment that's really high. So you've got to kind of gauge your level of comfort. But in general, I always recommend consulting with an attorney when you have a default judgment against you, because you're, like I said, you're at the end of your rope. All they have to do now is seize your bank account or garnish your wages, and then you're really stuck, and it's a lot more difficult to kind of get out of that hole. So if you have a default, you can file a motion to vacate like I explained, but it's always a good idea to talk to an attorney. Well, I hope that you understand now a little bit of the dynamics of how to vacate a default judgment. And if you'd like more information, or if you'd like to see a sample motion, I encourage you to pick up the phone and give me a call. My telephone number is 973-949-3770, or you can email me directly at plamont@peterlamontsesq.com. I'm available to take your calls, to answer your emails. I really want to help you understand the law. So until next time, don't forget, subscribe. Click the button below to like this video. Share it with your friends if it's helpful. And don't forget to look at the iTunes App Store to download our free app, which is available for iTunes and the iPad, and it allows you to ask questions directly to an attorney in our office, get an answer, and it's all free. So thanks for joining me, and I'll see you next time.